Hi. The first mechanism stated in Policy Statement 9 to enhance and protect shareholders' rights was by clarifying the application of rules relating to the oppression of members' rights. Such a scheme was engineered by the incorporation of Sections 195 and 346 of Companies Act 2016. Shanti Rachagan confirmed that Section 195 is not a standalone provision and must be read together with Section 346 because the former enhances the right of a shareholder to review the company's management, which was not found in the repealed Act, whereas the latter protects such right by widening the range of shareholders who can obtain an oppression remedy. Firstly, the traditional rule of directors having exclusive powers to manage the company under Companies Act 1965 was modified by Section 195. Mohammad Reza asserts that even though the 1965 Act did allow shareholders to question the board at general meetings, Section 195 subsection 1 imposes a mandatory duty upon the chairperson of a shareholder meeting to provide a reasonable opportunity for shareholders to debate, challenge, and make binding recommendations on the management of the company. Chan Meng adduces that unlike Section 346, which is a remedial provision, Section 195 is a preventive provision that averts any oppressive business decisions de novo. Even though Section 195 does blur the separation of power, it enhances shareholders' participatory rights while ensuring the accountability of directors towards the shareholders' interests and concerns, which was inhibited in the repealed Companies Act 1965. Besides, Section 195 is further strengthened by the wider application of Section 346, which provides statutory remedies for a wide range of shareholders when the affairs of the company are oppressive, disregard of his interests, discriminatory, or prejudicial. Section 346 is quite similar to Section 181 of Companies Act 1965, but Lavinya Kumarendran argues that Section 346 allows the court a more liberal approach in protecting shareholders facing oppressive acts. Dr. Kamar states that Section 181 of the 1965 Act was inherently restrictive as the court was rigid in providing locus standi for a shareholder for an oppression remedy. For example, in Ri Tong Eng Sundarian Berhad, the court held that only shareholders' names appeared on the company's register of members are allowed an oppression remedy under the 1965 Act. Nevertheless, the federal court in Owen Sim and Piasau Jaya extended oppression remedy to equitable shareholders to prevent the statute being used as an engine of fraud. Chan Meng argues that such a decision is the foundation of today's Section 346 and CLRC's consultation document supports that Section 346 should cover equitable shareholders too. For further support, reference can be made to Section 216 subsection 1A of Singapore Companies Act 2006, which is in pari materia with Section 346 to interpret the novel Malaysian provision. In Chow Kwok Ching and Chok Kwok Chi, the Singaporean court held that an oppression remedy can be extended to an equitable shareholder too. Thus, Aiman Nariman recommends that Section 346 should include the expression complainant, referring to Section 345 to reflect the original intention of the provision to protect a wider range of shareholders. Each coin has two sides. Despite the enhancement of shareholders' rights under Sections 195 and 346 respectively, the objective of those provisions are hindered due to certain issues. Firstly, even though Section 195 subsection 1 allows a shareholder to give recommendations, Section 195 subsection 3 states that those recommendations are only binding if it is in the best interest of the company and passed by a special resolution or ordinary resolution if provided under the company's constitution. Professor Abu Bakar argues that Section 195 is silent on who should prove the best interest of the company. But in Petra Perdana, members' resolution was held as an indication of it. However, the biggest hurdle of providing a binding recommendation is Section 195 subsection 3b, which requires the shareholder to comply with the procedural requirements of Companies Act 2016 to pass a special resolution, which is indisputably strenuous. In essence, for a special resolution, a not less than 21-day notice, including the text of resolution, should be given and be accepted by at least 75% majority of members to be binding over the company. Thus, no impromptu recommendation by members, particularly minority shareholders, is likely to be binding on the company as the majority rule applies. If the company's constitution allows, an ordinary resolution is sufficient. But This method is elective under the new regime, as Mara and Dato Abdul Rahim confirmed that the threshold to make a binding recommendation is elusive. Li Yao argues that the stringent procedure severely curtails the objective of Section 195. Furthermore, Section 346 is also flawed as the grounds for an oppression remedy is ambiguous as it was under the 1965 Act, because the novel provision also fails to define what constitutes oppression, disregard of interest, discrimination, or prejudicial. Despite the intention of Policy Statement 9 to clarify the rules on shareholders' oppression, the failure to provide a definite guideline results in conflicting interpretations. For example, in Re Kong Tai Sawmill, Lord Wilberforce explained that there must be a visible departure from the standard of fair dealings for an oppression remedy. However, this approach was criticized to be incorrect in Kumagai Gumi and Xenocon Kumagai Sendirian Berhad. The federal court in Pan Pacific Construction Holdings and New Key Corporation addressed such a dilemma and stated that the concept of fairness is required to be applied rationally till the legislative body provides statutory guidelines to the provision. Justice Rumley in Dato Lo Ngong and Bunting Hok Hin Estate held that as there is no statutory definition provided, the petitioner under Section 346 is obliged to prove the oppression with compelling evidence, as the court will not interfere in the management of the company unless it is necessary. Thus, Aisha Bidding contends that the potential of Section 346 is abridged due to the arduous burden imposed on the shareholders to prove their case. In short, it is accepted that Sections 195 and 346 to a large extent have enhanced and protected shareholders' rights in comparison with Companies Act 1965. But there is still room for reform, and by implementing the suggested reform, the fullest potential of the provisions will be actualized. Thank you.
The second approach under Policy Statement 9 of the consultation document is to enhance and protect shareholders' rights by refining the application of the statutory derivative action. The essence of a derivative action stems from the ability for minority members to commence action against wrongdoers of the company. The party to action aimed would be the company, as the court would issue an order for the wrongdoers to pay damages to the company. It must be noted that no further action can be taken against the wrongdoers, as this order would bind other members. This is also to avoid any multiplicity of actions. Derivative action is recognized under the law under both Companies Act 1965 and Companies Act 2016. However, a large change is made with the implementation of Companies Act 2016, where under Section 347, subsection 3, Companies Act 2016 provides that the statutory derivative action is exclusive cause of action, as the common law derivative action has been abrogated. In comparison, Section 181A, subsection 3, Companies Act 1965, presents the statutory derivative action, yet remains silent on the common law derivative action. This gives incentives for courts to apply the English concept of the common law derivative action. This is found under Foss against Harbatul, which is later adopted in Abdul Rahman Aki against Krubong. The first discussion at hand is the abrogation of common law derivative action provided under the Companies Act 2016 has provided for a streamlined approach in comparison to the Companies Act 1965. With only one approach, Section 347 to Section 350 provides the steps to using such an action, where it provides a two-stage process. Section 347, subsection 1, Companies Act 2016, is used in granting the application of leave through the prima facie test derived from Muhammad Shoaib Ishaq against Celcom. These observe the attaining of leave of court in good faith, with reasonable notice and acting in the interest of company. As long as one can obtain the grant of leave of court, the straightforward application would assist in increasing shareholder protection. New Zealand and Australian jurisdiction had also abrogated the common law derivative action, which is also followed by the CRLC as creating the new regime. Ayman Nariman states that common law derivative action and its exceptions are not streamlined and implemented restrictively, denying fair remedies to the shareholders. For example, exceptions provided under Foss against Harbatul, such as fraud of minority, did not extend towards cases of negligence. In contrast, the statutory derivative action would make no such limitations, making it more refined as well. Besides this, the common law derivative supports majority shareholders. The proper plaintiff rule and internal management rule, even with exceptions, was extremely restrictive. Professor Seeley believes that the extent of restriction makes it discouraging to apply. Thus, the statutory derivative action provided better protection for minority shareholders. With common law abrogated in contrast to Companies Act 1965, it is only more advantageous to the minority shareholders, as all restrictive and majority-favored rules have become irrelevant. Removing common law derivative action would not always contribute to a larger protection towards shareholders. This is due to the fact that flexibility is much less. as only one avenue is available under Companies Act 2016, which is the statutory derivative action. The most deliberate exception from the rule of Foss against Harbatel includes where the justice of the court requires, adopted in Tan Guang Ng against Ng Kong Hee. Limiting it to a statutory derivative action may remove this particular aspect that would highly protect shareholders and apply in numerous situations with more flexibility. Such flexibility has been removed in the current regime. Furthermore, the difficulty of the process of commencing statutory derivative action occurs as there is only one avenue. Melissa Hoffman shows that the rates of success in cases were too low with statutory derivative action. This was often due to the requirements to obtain a standing being too difficult. Thus, the majority of cases were dismissed. As there is only one method in comparison to Companies Act 1965, a reform that could be suggested is for courts to lower the threshold for more successful applications and to give actual protection to minority shareholders. Conversely, there is also uncertainty in the position of multiple derivative actions, which occurs when the shareholders of a parent company would bring action on behalf of the subsidiaries of the company above. This concept has been derived from the common law. Thus, it comes into question on its applicability with the abrogation of common law derivatives under Companies Act 2016. However, in Rajan Singh Sidhu against Zavarco, High Court accepted that multiple derivative action do apply in Companies Act 2016. Section 347, subsection 3, Companies Act 2016 had not excluded multiple derivative action. Notwithstanding, courts have no further justification in its application other than it being a lacuna, placing this concept as uncertain. Thus, it is hard to say that a refined approach is achieved. Emma Neumann calls for a statutory reform for multiple derivative action to be codified. Hong Kong Companies Ordinance and Australian Corporation Act 2001 can be observed in its application. This particular codification would accomplish the intended objective, as well as protecting minority shareholders' rights in comparison to Companies Act 1965. Thus, it is concluded that the Companies Act 2016 has achieved its objective to a large extent in comparison to Companies Act 1965 by providing better protection to minority shareholders with a streamlined approach, but it is indisputable that there are some restrictions imposed in a practical sense for the new regime to attain its full potential.
Hello, Ms. Saratha. So according to Policy Statement Number 9, the third approach taken by the Companies Act 2016 to enhance and protect shareholder rights was to amend the rules relating to the variation of share rights. In my part of the presentation, I'll discuss 4 issues. Firstly, what are share rights? Secondly, what will amount to a variation of share rights? Thirdly, the change in law regarding the ability to vary share rights. Fourthly, the change in law regarding the introduction of preemptive rights to new shares. Now, shares are generally classified into 2 categories, preference shares and ordinary shares. Different classes of shares will grant different rights to the shareholders. So, for example, preference shares will grant the shareholders priority in terms of dividends and also grant them a priority claim in the company's assets when the company is wound up. On the other hand, ordinary shares will grant the shareholders the rights to vote and to be more involved in the decision-making process of the company. The law recognizes 3 situations in which class rights have been varied. Firstly, when any rights relating to the class of shares have been varied. Secondly, where any provisions relating to the variation of class rights in the company's constitution have been amended. And thirdly, when new preference shares ranking in pari passu with the existing preference shares have been issued without authorization by the company or by the terms of issue of the existing preference shares. There are 2 significant changes in the law relating to share rights from the Companies Act 1965 to the Companies Act 2016. The first change now enables the variation of share rights, and the second change now introduces preemptive rights to shares. Let's discuss the first change. Under the 1965 Act, the variation of class rights were not allowed if those rights were provided for by the memorandum of the company. This is provided for by Section 21(1)(b). However, under the 2016 Act, class rights are allowed to be varied. In fact, procedures to make such variation are found in Section 91. The critical question to be answered is, does the ability to vary class rights serve the best interests of the shareholders in accordance to Policy Statement 9? In theory, the ability to vary class rights is advantageous because it grants flexibility and thus allows shareholders to adapt to changing market conditions. So, for example, in times where the company offers high dividends, the shareholders may vary their rights attached to their shares and earn more from the dividends. In short, shareholders have more control over the benefits of their shares than ever. However, on the flip side, the flexibility also comes at a cost. Shareholders are no longer guaranteed the same rights as they had when they first purchased the shares because these rights are now subject to change. As a result, shareholders, and especially minority shareholders, may have their share rights amended against their will by the majority shareholders who are usually in control of the company. As you can see, the ability to vary class rights is a double-edged sword. Nonetheless, if the variation of share rights causes disadvantage to the shareholders, they may prevent or even challenge the variation under the 2016 Act. Firstly, Section 91 provides procedural obstacles to vary class rights. This provision states that if the company constitution provides for the procedures, then those procedures must be fulfilled. If the company's constitution does not provide for procedures, then approval must be obtained from 3/4 of the relevant shareholders. And given that 3/4 majorities is needed, this procedure is a considerably large obstacle to vary share rights. However, it must be noted that the minority shareholders will always be at the risk of being outvoted. Secondly, if the share rights have been varied against the shareholders' will, the shareholders may have a right to challenge the variation in court through Section 93, subsection 1. If the challenge is successful, then the court will order the variation to be disallowed. However, the shareholders commencing this challenge must represent at least 10% of the total voting rights in the class. Otherwise, they are not entitled to challenge that variation. Again, this potentially means that minority shareholders are at a disadvantage. But still, minority shareholders can always work together to make up that 10%. The second change from the 1965 Act to the 2016 Act is with regards to the unauthorized issue of preference shares ranking in pari passu to the existing preference shares. This unauthorized issue of shares is equivalent to a variation of share rights because it dilutes the voting and distribution rights of other shareholders. Therefore, the 2016 Act had introduced Section 85 to grant existing shareholders a preemptive right to new shares. Consequently, any new shares must be first issued to existing shareholders so that they have an opportunity to maintain their voting and distribution rights. In turn, this enhances and protects their interests. In summary, the 2016 Act has allowed shareholders more control over their shares by allowing the variation of share rights under Section 91 to challenge the variation of share rights under Section 93 and by granting preemptive rights under Section 85. Hence, more power is vested within the shareholders through the 2016 Act in comparison to the 1965 Act. And as such, I think it is safe to say that the 2016 Act is successful in enhancing and protecting shareholder rights.
The fourth approach, as stated in Policy Statement 9 of enhancing shareholder rights and protections, was by strengthening and refining the procedures on dividend. This is done by the solvency test under the 2016 Act with the introduction of Section 131, 132, 133, which deals with the distribution of profits to the shareholders. In Hilton International Limited and Hilton, under the 1965 Act, there were two requirements for the payment of dividends. It had to be paid out of the company's profits, and the company was solvent. This judicial requirement is now codified under Section 131. The test for solvency for the purposes of distribution is whether the company is able to pay its debts when the debts are due within 12 months after the distribution is made under Section 132 sub 3, or where the distribution has exceeded the level where the distribution could have been properly made, and the company can recover the distribution from the shareholder or hold the director of the company liable as per Section 133 sub 3. This enhances the director's accountability and safeguards creditors' interests. The current Act protects shareholders' rights in contrast to the previous Act because it provides certainty as to when the dividends can be distributed, which is when the solvency test has been satisfied, unlike the former Act where there was a doubt on the phrase payable out of profits. In Dato Ga Ah-Tee and Kwan Leo Chun, the court held that the 1965 Act was ambiguous and uncertain. Due to this, in Mara Developments and B.W. Roffer, court stated that the company is required to be solvent when declaring dividends but not when distributing. This has since been modified in the current Act as Section 131 sub 1 provides that the company must be solvent while distributing the dividends as well. Then, solvency is determined by looking at the company's ability to pay off its debts as it falls due and or where its assets are more than its liability. The 2016 Act also enhanced the shareholders' rights to recover unlawfully distributed dividends with the imposition of a stricter liability unlike the former Act. In order to impute civil liability on the director, it must be proved that he knew that the dividend was not out of the company's profit at the time of payment as under Section 133 sub 2. The current Act imposes the liability on the director towards the company, unlike Section 365 sub 2 of the 1965 Act, where it is limited to the creditors only. Under the contemporary regime, the director would be liable to the extent of the amount exceeding the value of any distributions of dividends that could properly have been made. Under the current Act, there is an enhancement of the right to recover unlawfully distributed dividend where the director knowingly permitted it to be paid not from profit would be personally liable to compensate the company as under Section 133 sub 2, and if the company recovers the whole amount from director, it would then be entitled to recover contribution from anyone who has been found liable under Section 133 sub 3, with the exception that the shareholder has received the distribution in good faith with no knowledge that the solvency test was dissatisfied. There are flaws which restrict the potential of provisions under the current Act. Firstly, certainty under Section 132 sub 2 is contentious due to its wordings. The legislature has attempted to prescribe a simple solvency test, but it has failed because the test for payment of dividend is under Section 132, but there are other solvency tests under the current Act. According to Section 132 sub 3, a company is regarded as solvent if it is able to pay its debts when the debts become due within 12 months immediately after the distribution is made. The wording is different from the various tests in Section 112. However, there are similarities with the test described in the latter section, that is, the company will be able to pay its debts as the debts become due during the period of 12 months immediately following the transaction. For example, Section 132 has not clarified whether unrealized profits can be used for payment of dividends. There are conflicting decisions whether the company can declare cash dividends from its unrealized profits. In ex parte Westburn Sugar Refineries, the company may issue only bonus shares from its unrealized profits. However, in Dimboola Valley Tea Company and Lorry, a company may pay cash dividends from its unrealized profits due to the revaluations of its fixed assets, provided that the revaluation is bona fide, it was done by a competent independent valuer, assets were revalued, and there was a genuine appreciation in value. Furthermore, under the current Act, the power of shareholders to declare dividends had been reduced. Previously, the power to declare dividends was generally shared between shareholders and directors. However, in the current Act, the director is the sole authority to authorize payment of dividends. Section 131 sub 1 provides that before distribution is made by a company to any shareholder, such distribution shall be authorized by the directors of the company. Some reforms can be implemented here. In my view, Section 133 sub 2 of the 2016 Act could be reformed, where Shanti Rajagan recommends that the legislative body should clarify as to whether Section 132 sub 2 should be inclusive in regards to unrealized profits being a part of dividend payment. To conclude, it is true that the rules of dividend have been clarified to a large extent and have enhanced the shareholders' rights. However, the ambiguity of the new provisions have curtailed the protection of this current Act.